Mooting involves a simulated court hearing, and a part of the process is preparing written submissions. Written submissions are a structured outline of the arguments that a team will put forth during the moot. They allow your opponents and judges to understand what arguments you will be making and help them keep track of your submissions.
Let's now turn to what written submissions should look like. Generally, written submissions will be divided into 5 main sections. First, the title page, which generally serves to identify the submissions. Use this page to outline the court the matter is being heard in, the case name and number, and whether you'll be appearing for the appellant or the respondent. A template will be provided for you. Second, issues for determination, which briefly lists each submission in line with the grounds of appeal identified in the problem question.
Third, numbered submission points. This sets out the team's arguments in detail and will take up the majority of your written submissions. Use headings for each of the issues for determination and follow these with numbered paragraphs that set out your argument and the relevant law. A good structure to use in this section is the IRAC method, which stands for Issue, Rule, Application, and Conclusion. Begin by identifying the issue or the legal question that must be answered. Second, state the rules or law pertinent in deciding the issue you identified. This will often require citing relevant statute or case law. Then, spend a couple of sentences applying the rules to the specific facts of the problem question. Explain why a particular rule or authority applies or does not apply to the present case. Finally, conclude by directly answering the question presented in the issue. Remember that written submissions should be as succinct as possible. Use subheadings where appropriate, avoid long and lengthy paragraphs, and watch for grammar or spelling errors. Your written submissions should be an outline of your argument, which can be expanded upon in your oral arguments. All legal principles used in one's written submissions should be referenced by footnotes in compliance with the Australian Guide to Legal Citation. Where possible, the exact page, paragraph, or section should be pinpointed.
Once you have made submissions on each of the issues for determination, you can now move to the fourth component of written submissions, orders sought. This will usually be no more than 1 or 2 lines that sets out the result that the party seeks to achieve, that the appeal be dismissed, or that it be allowed with costs. Fifth and finally, written submissions should finish with an alphabetized list of all references the team has used. Cases should be listed first and legislation second, and should be compliant with the Australian Guide to Legal Citation. Now let's turn to some tips on how to conduct research for written submissions. It's a good idea to start by acquiring a general understanding of the area of law of the moot. Textbooks and legal encyclopedias are a good place to start. In particular, Halsbury's Laws of Australia on Lexis Advance and Laws of Australia on Westlaw offer a great introduction to a number of different subject areas that you'll encounter in your moots. Once you've developed a general sense of the relevant law, you can look for and read cases on the specific issues of concern in the moot. Again, search functions on Lexis Advance or Westlaw AU are a great place to look for leading cases, which you can use to establish principles of law, as well as factually analogous cases, which are used to support your arguments.
Let's now have a look at some examples of written submissions. Example 1. This is a poor example of written submissions. As you can see, this person has used a long and lengthy paragraph to detail their argument, and they don't have a clear structure. Instead of following IRAC, arguments are listed out without making it clear what is the applicable law and therefore what standard is being used to judge the facts against. This person also does not separate out different arguments into subheadings or at least different paragraphs. The arguments about foreseeability and reasonable precautions are discussed together, so the reader is unable to differentiate them. Finally, these submissions do not link the arguments to the issue, which is that the respondent breached their duty of care. This makes it difficult for the submissions to assist in the overall argument.
Let's move now to the second example. This is an excellent example of written submissions. Each issue and sub-issue are identified clearly, and the relevant law is set out and well structured. Not only do these submissions persuasively apply the law to the facts in a concise and methodical manner, but each argument also links back to the issue. We hope this video has been helpful in learning how to tackle written submissions. This aspect of mooting is a great way to develop your skills in legal research, drafting legal arguments, and practicing legal citation. Make sure you sign up to the Law Society's internal mooting competitions so you can get a chance to put these newly learned skills and knowledge into practice.